Hi everyone, welcome along to the Brodie's Personal and Family Academy. And today we're going to be talking about challenging forces in financial planning. Our focus will be the consequences of relationship breakdown. My name is Stuart Gibson and I am an associate in the Personal and Family team here at Brodie's. I will move on to the learning outcomes and go through what we're going to learn in a little bit more detail. So the overarching theme of today is challenging forces in financial planning. So what we want to help you to do is understand the potential challenging forces which can crop up in financial planning in certain circumstances. So those circumstances are when there's the breakdown of a marriage or the end of a cohabiting couple's relationship. So that's what we want to cover. But more than that, we want to try and give you the tools to be able to speak to your clients about these issues. And perhaps most importantly of all, we want to give you an idea of where these problems might arise and how to tackle them. And the key message from us is how legal advice, thinking about these issues early and collaborating with us to make sure we get the right solutions for clients can, if not entirely solve the problems, then it can certainly mitigate them. Okay, so first of all, you're going to hear from me. I will chat you through the consequences of divorce on wills. Just before I do that, I would like to introduce my colleagues who are joining me today. Hopefully you can see all three of us. As I say, my name is Stuart Gibson. I am an associate in the Personal and Family team, usually in normal times based from the Edinburgh office, and my focus is very much traditional private client work, so very much falling on the personal rather than family side of the Personal and Family team. My colleague Fraser Mackay, usually in Aberdeen, joins us. He too is a specialist in all things private client, so that is wills and trusts and executories, powers of attorney, and all those sorts of things. And I'm very pleased to say we're also joined by my colleague Zoe Ray, who is an associate in our family law team. So Zoe falls very much on the other side of the Personal and Family team, focusing on all things family law. So you'll hear from both Zoe and Fraser shortly, but to kick off on the substance from me, the first question is, what happens when a marriage comes to an end to the wills of the people who were in that marriage? So I'm sure lots of you will have clients who are very happily married. They will, I hope, have wills in place. I'm sure that is on the list of things that you will discuss with them. It may well be on some sort of checklist that you use. And hopefully your clients have wills in place. But what happens if one of those clients comes to you and says, my wife and I, my husband and I, or indeed my civil partner and I are not having a great time. We think we're going to divorce and we want to know what the consequences of that are. Well, one of the things to think about is what happens to those wills which were put in place when they were very happily married, and what you can do to ensure that firstly you understand that, and secondly you take action to rectify anything that is not what the client wants. So the answers to all of this are found in the Succession Scotland Act of 2016, which always seems like relatively modern legislation, but I suppose it probably isn't now that we're in 2020. So what that act says is that if you get divorced and you have a will which predates the divorce, which appoints your spouse or civil partner as an executor, a trustee, or a beneficiary, then they are treated for the purposes of interpreting that will as though they have predeceased you. So once the divorce is finalised, your spouse or civil partner is treated for the purposes of interpreting the will as though they have predeceased. So that is to say that they can't be an executor and they can't be a beneficiary. Can't be a trustee of any ongoing trusts. There are a couple of little caveats to that. The first of which is if the will expressly provides that notwithstanding a divorce, the spouse should continue in the role of executor or trustee or beneficiary, then that is what will happen. I don't think I have any clients who countenance the prospect of a divorce when they are often newly and very happily married and are looking at wills for the first time, but it's worth saying that it's something that we can do. I guess the question for the client in that circumstance is, are you sure you'll still feel the same when a divorce is happening? And I suspect the answer to that might be no. The other thing to mention is appointments of guardians in wills. Those are unaffected by these provisions. So if a spouse or civil partner is appointed as a guardian to the deceased person's children, then those provisions in the will will continue to be read as though the spouse or civil partner has not predeceased. I think something of a policy decision there to ensure that where both parents of the child are involved, they continue to be involved following the death of one. So that is another caveat to the rules. Otherwise, they're pretty far-reaching, and I think a very important point to make, especially for the financial advisors amongst us, is in relation to special destinations, otherwise called survivorship destinations. So these crop up often in titles to properties. The title will say the house is owned by Stuart and Fraser and the survivor of them. If I die, that means that Fraser gets the house, not regardless of what my will says. So irrespective of the provisions of the will, the house would pass to Fraser. The point to take away is that these provisions extinguish that survivorship destination as well as the provisions of the will. Another thing which I think is particularly important for the financial professionals amongst us is just to say that special destinations crop up in investment accounts and other financial products as well. So they're not only things that you find in titles to houses, they can appear in investment accounts as well. So the overall message is these are the provisions if a couple divorces, this is what happens to their wills. But the overarching message is make sure you think about this if you have clients who hit a rocky period in their marriage. So that is all from me for now. I'll now pass you over to Zoe, who will cover all things family law.
Thanks, Stuart. I'm going to focus principally on divorce and separation and how that can impact upon a client's financial plans. Nobody, as Stuart mentioned, wants to think about things going wrong when they're in a happy time in their life, but the reality is, as most of you will be aware, that many relationships and marriages do break down. And that can have a really significant impact on financial plans that have already been made. And I think the most important thing to take away from this, if you're a financial planner, is that clients really should not be making financial plans in isolation. They need to look at what might happen and things that they might not want to think about down the line, but they really do need to be aware of. In relation to financial provision on divorce, potentially one of the main things that can throw a spanner in the works in terms of financial planning. The courts and the law in Scotland looks at fair sharing of matrimonial property between spouses or civil partners. And when they're doing that, the starting point is equal sharing. But there is potential for the court to consider an unequal division of property to address certain issues such as economic advantage or disadvantage, the financial burden of childcare after a divorce, and also potentially the source of funds arguments that might be advanced in relation to pre-marital or non-marital assets. And that's potentially where the biggest issue comes into play here. The general provision is that gifts and inheritance are not included in the matrimonial pot in the event of a divorce. And that might, you think, give some comfort to a situation where a family has decided to make plans to gift money or assets to a child who then goes on to get married and subsequently divorces, but it's not quite as simple as that. If a gift or an inheritance is then converted, it can become matrimonial property. And the best way of explaining that is to give an example. So if you have a son who has inherited a large sum of money from parents who have died, and they've made those provisions in their wills, if that money stays as cash in the bank or in the form it was inherited, then it's fine, it's not within the matrimonial pot. But if the son then goes on to invest that money, for example, in buying a holiday home or reducing the mortgage or buying another asset for use during the marriage, then potentially it becomes matrimonial and therefore is in the pot. It may be in some circumstances that where there is a degree of goodwill and civil relationship between the separating couple, they can reach an agreement on things like that if both parties recognise that this was inheritance and they're happy to agree that's recognised in the divorce, but that's not always the case. And if it comes to it and you're advancing arguments in court, there is no guarantee that you will be able to protect that property or that asset. The court does have discretion to decide what's fair in any particular circumstance, and your source of funds argument may just be one amongst a number of competing arguments in a divorce case. The other thing also to bear in mind is about resources. So it may be that an asset is non-matrimonial in terms of it doesn't fall into the pot to be divided, but the court has to look at, when it's making any orders for financial provision, what resources the party has. So it may be that the asset itself is not matrimonial, but it can be taken into account when looking at a party's ability to pay any capital settlement or other financial order that's made by the court. So given the potential impact, it's important to think about what steps can be taken to preserve financial plans and to protect assets in the event of relationship breakdown. The best way really to plan for financial consequences of a marriage breakdown or the end of a civil partnership is to look at a pre or post-nuptial agreement. It's essentially a contract between the couple who are intending to marry or perhaps are already married to look at all or some of the financial provision aspects in the event that they separate or divorce. As far as the law is concerned, provided the pre or post-nuptial agreement has been validly legally entered into, the court will have regard to the terms of those agreements. And from my own perspective, I'm clearly seeing these are becoming increasingly more popular in Scotland, and not just for the rich and famous. I have done one or two prenuptial agreements for people who you might consider to be famous, I suppose. But for the very vast majority, it's much more ordinary people, and it's often to protect family wealth, or also in a second marriage situation where a couple are perhaps in their 40s and they've amassed some assets, or they want to make sure that they protect what they've kept from the previous breakdown of the previous marriage. So I appreciate it's not something that you want to think about when everything's fine and happy, but it's well worth considering if you do have assets that you want to protect. Essentially, it enables one or both parties to ring fence some assets and to set out a blueprint essentially for what happens in the event of a separation. So in the example that I referred to earlier about a son who had inherited wealth that he then perhaps used to buy a second property or a holiday home, you could expressly provide for that property not to fall within the matrimonial pot in the event of a divorce, thereby protecting the funds that he had inherited and the asset that he acquired using them. The advantages of having a prenuptial or postnuptial agreement are fairly obvious. It limits uncertainty in the event of a relationship breakdown. You can be a bit more clear about who's going to retain what and how particular assets are going to be dealt with. It can also save considerable time, cost and stress by avoiding litigation. In terms of cost, I mean, what you might spend on a prenuptial agreement, you potentially could spend 10 times that or perhaps more in the event of litigation. So perhaps on that alone, it's worth doing. And as I mentioned, you can have a pre or post-nuptial agreement, so it can be entered into before or during the marriage. And it may be that a situation arises once the couple are married that needs to be dealt with, and there's no prohibition on doing that. Essentially, it's an insurance policy. If things never go wrong, you don't have to worry about it. But if they do, then you know you've got the certainty and the clarity there to hopefully make things a bit more straightforward. But obviously this isn't a situation that affects just married couples. It can also be an issue for cohabiting couples. So we're going to look at what happens in relation to cohabitant separation also. As I've said, it's not just married couples who potentially have to deal with these issues. More and more couples, as you'll be aware, are choosing not to get married or to form civil partnerships. And the law in Scotland does afford certain limited rights to people who are living together as if they were husband and wife or civil partners. And that applies to both same-sex and opposite-sex couples. The law here is contained within the Family Law Scotland Act 2006. and provides fairly limited rights to cohabiting couples in the event of a separation, limited in the sense that they're not equivalent to those afforded to married couples. So really only an application for a capital sum can be made to the court in the event that that's necessary. You can't ask the court to make a property transfer order or a pension sharing order, and there's no option to apply for aliment as you would have if you were a married couple or civil partners. The provisions at the moment are currently subject to review by the Scottish Law Commission. They've had a consultation and reform is imminent, but at the moment the law as it stands does provide these limited rights for cohabitants, and if anything those rights are potentially only going to become more wide-ranging, so it's very important to be aware how these rights can impact on financial plans. The key provision in relation to cohabitation is Section 28 of the Family Law Scotland Act. It's quite a complicated provision, and any lawyers who come across Section 28, for most it's not their favourite thing to deal with because it can be very, very complicated. The right to make a claim for financial provision is not automatic. In order to do so, an applicant must show that there has been economic disadvantage, which has been to the benefit of the other party, and being disadvantaged of itself is not enough. So you might have invested money in something or spent money for the benefit of someone else, and that's to your disadvantage, but you have to show a corresponding advantage to the other person or indeed to any child of the relationship. It can lead to very difficult and complex litigation. Often there's quite a detailed offsetting exercise undertaken by the sheriff, and the sheriff or the judge in the Court of Session has very wide discretion as to the type of order that it makes. Sometimes no order is made at all because there's advantage and disadvantage on either side, and the court can look at all of the circumstances. Accordingly, it can be very difficult as lawyers to predict whether or not a claim will be successful and to quantify that claim. So there's a significant degree of uncertainty around about cohabitation claims. It's also important to be aware that if you're making a claim, you must do so within 1 year of the date of the end of your cohabitation, otherwise you lose that right entirely. There are options if you go past the 1 year time limit, but you're really then dealing with unjustified enrichment, and it's not straightforward at all. One of the main examples of this that we see is a situation where, for example, couples buy a property together, something that happens every day, and they either invest different amounts in the property in terms of a deposit, or one contributes more and they don't reflect that either in the title deeds or in some other agreement. If that property was to be sold in the context of a separation, the default position would be 50-50, irrespective of the contributions that either party had made. The other situation that arises really quite frequently is perhaps one party to the cohabitation owns the property and the other person moves in, and they don't do anything about the title. It remains in the name of one party, but the other one might make significant contributions, for example, to reduce a mortgage, and there's an obvious unfairness there that obviously has to be dealt with. So in the context of cohabitation then, what can you do to protect assets and prior financial plans in that situation? Much like a prenuptial or post-nuptial agreement, you can enter into a contract as a cohabiting couple to regulate what happens in the event of your separation, and that's just a cohabitation agreement. It does what it says on the tin. You just enter into this agreement and prescribe, in the event of a separation, what's going to happen to various things like property and any other assets that you own together, or joint savings, or anything like that. It can be used to cover a very discrete and specific situation, like the purchase of a house, or if one person's going to pay off debt in the name of the other. It just provides that clarity about who's contributing what and who's doing what, and what's to happen in the event of a separation. It can also be used to go further if you want to do that than what might be available to you in the event of a separation. So you might be able to agree in advance that in the event of a a separation, there is the option to agree between you the transfer of the property to one or other party, or to make provision for some form of short-term ongoing financial support between cohabitants that wouldn't be available if it was left to making an application under the law. Much like prenuptial agreements and postnuptial agreements, you can put that in place before you cohabit or while you're doing that, and you can update it as you go along, because particularly if it's a lengthy cohabitation, much like a marriage, things change over time, assets come and go, and it doesn't have to be something that you do at the outset and never look at again. It can be updated and it can evolve with your relationship, which is helpful for some situations. Again, much like prenuptial agreements, the main benefit really, why put one in place, it just keeps things clearer and provides the certainty that you're just simply not going to get if you end up in the situation of applying for a court order. Many people nowadays are in a situation where they can't buy a first home without help from parents, and often that's just made, and parents do that in good faith and want to help their child and their partner to get a foot on the property ladder, to be able to move forward without really thinking about what happens if it goes wrong. There are many people in that situation, and it might be difficult to have the conversation about, well, maybe you should put something in writing about this, but in terms of protecting the asset and protecting the wealth, it's definitely the right thing to do. And then if we just move on slightly from there, we have covered both the situations that we have for divorce and also separation of cohabiting couples. As you'll see, there are a number of issues you can probably think of just off the top of your head, situations of your own clients where they might be thinking about gifting some money, or they might be thinking about how to leave particular assets in a will, and certainly if they're going to be giving money to children, or even if they're making their own financial plans for later in life, it's important that they're aware of the consequences of what might happen in the event that they don't have the necessary protections in place, and what unforeseen events in the future, like separations, the impact that they can have on those plans and those arrangements. So that's all from me for now. I'm going to pass over to Fraser, who's going to deal with the next part of the presentation.
Thanks, Zoe, and thanks again to everyone for joining us for today's webinar. So as Zoe hinted at there, I'm going to be discussing what happens from a Scottish succession perspective on the death of a cohabitee, in particular what happens to their estate and how financial planners and lawyers can work together to help clients out in this area. After I've covered this topic, we'll then have a short conclusion, just going over what we've discussed today, and then hopefully we'll also have some time to answer any questions that have arisen during the webinar. So before we go too far into this topic, I think it's always just worthwhile to remember what we mean by cohabitees or cohabitants. So we're speaking about couples who are living together as if they are husband and wife or civil partners, but they've never actually taken the step to formalize the relationship by getting married or entering into a civil partnership. I think that's a fairly common arrangement in Scotland today, in today's society. However, with that said, I think a lot of people would be quite surprised to find out what the legal regime is, particularly where a cohabitee dies without a will. So taking that on forward, the first point to note that if a cohabitee dies without a will, the surviving cohabitant is not automatically entitled to receive a benefit from the estate, which, as I say, is quite a surprising outcome really for most people. If the surviving cohabitant would like to receive financial provision or inheritance from the estate, they will need to instruct their solicitor to apply to the court for financial provision from the deceased's net estate. As I say, I think most people find that quite surprising, just because a lot of people will assume that their loved ones will be the people that they will inherit from their estate. So if the surviving cohabitant instructs their solicitor to apply to the court for financial provision, the solicitor will make that application, and then it will be up for the court to decide, well, should the surviving cohabitant receive an inheritance from the estate? The first point for the court is to just look back to what I said there of, well, were the cohabitant and the deceased, were they living together as if they were husband and wife or civil partners? If that point can't be satisfied, the application is not going to be granted. Nevertheless, in most cases, if someone has gone as far as instructing their solicitor, chances are they were actually cohabiting. So we then move on to look at what other factors the court might consider when looking at these applications. So the first consideration for the court is to look at the size and the nature of the deceased person's estate. The court will also look at any benefits from other sources that have passed to the surviving cohabitee. So that might be the likes of pension death benefits or life assurance policy proceeds. It could also be heritable property that's passed by way of a survivorship or special destination, as Stuart mentioned earlier on. The court will also look at any rights or claims on the estate from other persons. So in these cases, because the deceased has died without a will, that could be the rights of children to claim legal rights. It could also be, going further up towards the deceased siblings or parents, just depending on the makeup of that person's family. And then lastly, the court has wide discretion to consider any other matter that the court considers necessary. So I don't envy the courts in these cases. There's a lot to consider, and it's ultimately difficult cases that they're dealing with here. But as I say, yes, lots of discretion for the court. If the court is satisfied and is prepared to grant the application, as the slide says, the court can order for a capital sum to be paid to the surviving cohabitant from the deceased net estate. The court can also order for movable and/or heritable property to be transferred to the surviving cohabitant. As the slide notes as well, there's a bit of a qualification there in that the surviving cohabitant cannot receive more from the estate than they would have received if the parties were married or in a civil partnership. And again, I think that's just a policy decision by the legislature. Another very important point to be aware of here is that there is a time limit for making these claims. So the surviving cohabitant must make their application to the court within 6 months from the date of their deceased partner's death. So I think we can all agree that 6 months in these sorts of cases is not particularly long. The surviving cohabitant has ultimately just lost the person that they live with, their loved one, and there's probably lots of things going on in their life as a result of that. But nevertheless, the law requires that this person must instruct their solicitor, if they want to receive inheritance from the estate, to go ahead and make that application. And I think another difficult point in this area of law is that if the surviving cohabitant is successful in making the application to the court, ultimately they will then inherit from the estate, but they'll inherit from the estate at the expense of the other family members, so the likes of deceased children or siblings, mother and father, that sort of thing. So in a way, there is, as I say, there's potential for these applications to become contentious, and really, I think if we can avoid these situations where you are almost pitting the surviving cohabitant against other family members, it's really going to be in everyone's best interest, because things can then just move on in what is, as I say, ultimately difficult circumstances. So we've looked at there, well, what's the position where a cohabitant dies without a will? Now we go on to look at, well, is the situation any better if they do leave a will? So they die, but they have a will. Now, the answer there is yes, absolutely, the situation is a lot better. So if cohabitants die with wills in place, the wills will stipulate what happens to their estate on their death. The whole idea of having to make an application to the court for financial provision is completely removed. That wouldn't be competent in these cases. The requirement to apply to the court for financial provision only applies where there is no will. So as I say, if wills are put in place, then absolutely the wills will outline and stipulate what happens to the estate. Even if the wills are simply straightforward and they just provide, I want the residue of my estate to pass on to my surviving cohabitant, that is enough. Of course, the will would be drafted appropriately, but that general idea is enough to just remove us from this very difficult area of law associated with making applications for financial provision on the death of a cohabitant. So our message, in terms of this part of the webinar, is absolutely, if you are meeting with clients and having reviews with them, and they're in, their circumstances match that, they're cohabiting together, they don't yet have wills in place, absolutely let them know that it's best to put wills in place to avoid this difficult area. And I'm sure everyone will be thankful for that, just because things will be much more straightforward at that difficult time, as I said. So now, just looking to conclude today's webinar, we've spoken there about forces in financial planning as a result of the breakdown of marriage and the ending of cohabiting couples' relationships. We have also, in particular, we've talked about the impact of divorce on wills. So that's beneficiaries, sorry, if the ex-spouse or ex-civil partner was a beneficiary, they'll be deemed to predecease. Likewise, if they're an executor or a trustee, doesn't quite apply for provisions relating to the guardianship of children. Zoe has spoken at length in connection with divorce and financial provision on divorce, and the importance of avoiding assets and funds falling into the matrimonial property pot for financial provision on divorce. We've also looked at the benefits of prenuptial and post-nuptial agreements, as well as similar points with regard to cohabitation agreements. In my part of the webinar, we also discussed the importance of cohabitants putting wills in place ultimately to provide a much straightforward future for themselves in due course. As the slide says, and I think we've all kind of touched on this point, that it's very rare for couples to enter into a relationship with a view as to, well, what's going to happen when the relationship ends. But it's important that, I think financial planners and lawyers work together to highlight these issues to clients, and ultimately to try and make things as straightforward for everyone as I say, that the clients will appreciate that, and generally it's in everyone's best interest to try and keep these things straightforward. Certainly careful and early planning is essential to try and keep clients right in this area, and as I say, they'll be very thankful for that. So now I think we do have some time to look at any questions that have arisen. I can see there we do have one question, which I think I will pass on to Stuart, if that's okay. So Stuart, the first question that we've had come in is, if couples are divorcing, do they need to wait until the divorce is finalised before they should think about making changes to their wills if they have wills in place?
Thanks, Fraser. Yeah, that's a really good question. And the answer is no, they don't have to wait, and in fact, they should not wait. So as we covered, the provisions that treat your ex-husband or wife or ex-civil partner as having predeceased, those only come into effect when the divorce is finalized, or dissolution or annulment or whatever it may be, but when the formal relationship is brought to an end. So from my point of view, I think the thing to do is, as soon as a client comes to you and says, I'm having these relationship difficulties, I think it may be coming to an end, what should I do? One of the things on that list should be, let's look at your will, because the will can be changed then, and you don't have to wait for the marriage or civil partnership to end before that can happen. I suspect there are possibly also things that can be done on the family law side, Zoe, and I don't know if you want to touch on that. I'm thinking in terms of separation agreements and those sorts of things.
Yes, I mean, certainly we would always include within a separation agreement a provision that deals with the existing rights of spouses to inherit from one another. But it's much better just to deal with the will straight away, because even in the most straightforward of situation, it can take a bit of time to get the separation agreement concluded, and there's always going to be that period in between separation and formalising your arrangements that you're sort of in limbo. So if you deal with your will straight away, there's no question, it's just dealt with then and there. So definitely be proactive and get your wills done as soon as possible if you're separating.
Okay, thanks for that both. The next question we've had that's come in relates to cohabitants dying without a will. So someone's asked, they're aware that there has been discussion around reform of the law in this area, and just looking for an update on that. So just because I spoke about that part of the webinar, I'm happy to deal with that question. So essentially the Scottish Government looked at this area of law and had a consultation last year in connection with intestate succession generally, so where people are dying without wills, and they did look at the question of should they be changing the law with regard to a cohabitant's right on death. Ultimately, it was felt, I think, that the respondents to that consultation, 2/3 were in favour of keeping the current position, where the surviving cohabitant needs to make an application to the court to receive an inheritance. But the Scottish Government also mentioned that they were going to continue to look at this area, carry out further research, and possibly refer this matter to the Scottish Law Commission. So we're going to wait and see with regard to whether or not there's any changes in this area of law, but certainly the message to clients is not to wait and see. We can ultimately avoid these problems by putting wills in place. And as I say, that whole regime about dying without a will just doesn't apply in that case. I can see we've had another couple of questions in. So the first question we've got here is, hang on, when a married partner dies and there are children from previous marriages, how is this treated? So when a married partner dies and there are children from previous marriages, how is this treated? So ultimately, the children of the previous marriage will be entitled to legal rights in the estate. They would have to be advised of their entitlement to legal rights. So that would be a part of the net movable estate, which I think we spoke about in one of our recent webinars. Essentially, yes, the children from the previous marriage need to be told that they are entitled to claim their legal rights. That is, of course, if they're not mentioned in the deceased's will. I don't know, Stuart, if you've got anything to add on that at all, or.
I think that covers it, Fraser. Again, the message is just that almost irrespective of what happens, the best thing to do to try and control what happens is to make sure that the married couple have wills in place. And then, yes, as you say, Fraser, legal rights are obviously a consideration here. And just to flesh out a little bit the point you made regarding legal rights, if the children from the previous marriage were provided for in the will, then they would have the choice between either taking their legal rights in their parents' estate or taking what they inherit in terms of the will. And the important point is that they can't do both. It's an either or choice for them.
Absolutely. Zoe, I think we've got maybe one question for you here. So someone's asked, can a cohabiting couple that are separating take into account sharing of pension assets in some way, presumably by offsetting against some other assets?
I suppose if there was agreement between the two parts of the couple, then potentially they could. They couldn't make provision for pension transferring in the same way as that spouses can. But I think what the person asking the question might be alluding to is, say, a situation where you've got a long-term cohabitation and one party has built up a large pension and the other party potentially has not worked so much and therefore has no or limited pension, and they might decide and agree in that situation that, for the sake of argument, the family home is transferred to the partner who doesn't have the pension, and kind of in recognition of that, the person with the pension would just retain that. But that would really only be possible in a situation where there's an agreement. It wouldn't be possible in the context of a Section 28 claim to ask for any sort of pension sharing. You would then be in the realms of economic advantage and disadvantage, which, as I've said, is quite complicated. So in short, yes, if you could agree something like that, but there's no statutory mechanism for doing so.
Okay, I think we've had another couple of questions in. So first, is there still reasons to have a cohabitation agreement if there are prenuptial agreements in place? So I think there's maybe a bit of clarification needed on that point, please, Zoe.
Yes, well, they're sort of two different things. So if you already have a prenuptial agreement in place, you would be having that agreement in kind of contemplation of your marriage. There would be an expectation that you're going to get married in the fairly near future. So there wouldn't be a necessity to have a cohabitation agreement on top of that. I wonder whether it might be useful to explain, if you have a situation, for example, which happens quite regularly now, that couples cohabit for quite a long time before they actually get married, and they may have a cohabitation agreement in place, and they would need to think about whether or not they need to update that if they're then going to get married. The the law in Scotland says that the court can have regard to any agreement between the parties regulating their financial arrangements. But really it would depend on the terms of the cohabitation agreement, because if it only covered certain things, that might not be sufficient to deal with everything that they need to do in the event of a marriage breakdown. So if there are significant assets or particular assets that they want to protect, it might be worth also considering a prenuptial agreement to make sure that in the event of a marital breakdown or the dissolution of a civil partnership, that the required protections are actually there. I think there's also a part of that question in relation to differences between Scottish law and English law in relation to financial planning. As things stand at the moment, there is no wording in the legislation that says if you enter into a prenuptial agreement it will be upheld, but the law says that any agreement with regards to financial arrangements between the parties, the court will have regards to that, and day in and day out these agreements are recognised, and the accepted position is that they will be taken into account provided that they are fairly entered into. So for example, that one party hasn't been kind of duped into it or under duress, or that there's been sufficient disclosure and all of that. And the position is broadly the same between Scotland and England. It didn't used to be. England had a slightly different approach before, but we're kind of coming more together on that now.
Okay, thanks very much, Zoe. I think we've maybe got one other question here. So if a couple is in a long cohabiting relationship, but only a short marriage, will only the assets built up during the marriage be the ones split, or does the court have discretion to look behind the marriage?
Again, this can become quite a complicated area, but many couples do live together before they get married. So the court will look at the assets built up during the marriage, so from the date of the marriage to the date of separation, but it's quite often not as simple as that. So what then becomes the couple's matrimonial home may well have been the property that they lived in together before they got married. So that will still be their matrimonial home, notwithstanding that they lived in it before they got married. And it may be that applies to a number of things, but if you take, for example, a pension or an investment that's contributed to both before and during the marriage, in the event of a divorce, they will only be looking at the value that relates to the period of the marriage.
Okay, thanks very much, Zoe, and thanks very much, Stuart, as well. I think that's probably just about all we have time for today. So again, big thank you to everyone for tuning in to the webinar. I hope you found it to be informative. The intention is that we will be running at least one more, if not possibly two more Brody's Personal and Family Academy sessions this year, perhaps one in October and maybe one in November too. So keep your eyes peeled for that, please. And if there is any other points, questions that have come up that you've not had a chance to ask us during the webinar, our details are available at the end of the slides and also on our website, where you can find all sorts of other content, not just related to personal and family, but all sorts of other stuff too. But as I say, thank you very much for joining us today. We'll get the recording distributed out to everyone that's attended. And as I say, hope you've enjoyed it, and we hope to have you for another session in the near future. Thanks very much.